Welcome to the case of YAA ANTWI vs. NTHC from D. Antonio's Law Series. Can a company take back an offer to sell you a house even after you've said yes? This question was at the heart of a landmark legal battle in Ghana, a true David versus Goliath story pitting a lawyer against her powerful employer. This is the case of YAA ANTWI versus NTHC, a masterclass in contract law that reached the highest court in the land. Our story begins in January 2005. YAA ANTWI, the head of the legal department at a company called NTHC, is at her desk. She's lived in her company-assigned house for years. Suddenly, a letter arrives that could change everything. It's from the company's board secretary. The letter explains that the board held an emergency meeting and decided to sell some of its houses currently occupied by staff. And then comes the crucial part. The letter says, and I quote, "In that regard, you are given the first offer to purchase house no." YAA reads the letter carefully. First offer, she thinks. The price is clearly stated. The payment period is set. To her, a seasoned lawyer, this looks like a straightforward, legally binding offer. It's not a vague suggestion. It's specific. A specific house, a specific price, a specific timeline. It seems like all she has to do is say yes. So, on the very last day possible, January 31st, 2005, YAA ANTWI does exactly that. She sits down and writes a formal letter back to her employer. In her letter, she states clearly, "I accept the offer to purchase the house at the stated cost." She confirms she will pay within the 6-month period, and to move things along, she asks them to provide the bank account details so she can start making payments. In YAA's mind, a contract has just been formed. There was an offer, and she has now accepted it. The deal is done. All that's left are the mechanics of payment. She waits for the company to send her the bank details. And she waits and waits. Days turn into weeks, and weeks turn into months. The 6-month payment window is ticking by, but there's complete silence from NTHC. No bank account details, no further communication, nothing. This is strange. Why would they make an offer and then not provide the means to fulfill it? Life moves on. In August of that year, YAA ANTWI decides to leave the company for other opportunities. The house issue is still unresolved, hanging in the air. Then, in November, nearly 10 months after the initial letter, she receives a shocking communication from the Deputy Managing Director of NTHC. The letter informs her that the board has decided to withdraw the offer. They claim they now need the house for new management staff and ask her to vacate the property. YAA is stunned. Withdraw the offer. She immediately fires back. "You can't withdraw it. I already accepted your offer back in January. We have a contract." She points out that the only reason she hadn't paid was because they never gave her the account details she had requested. To her, NTHC was breaking a legally binding agreement. NTHC, however, saw things differently. They believed no contract ever existed, and they were perfectly within their rights to change their minds. With both sides firmly entrenched, the stage was set for a major legal showdown. YAA ANTWI decided to sue her former employer, seeking what is known as specific performance, a court order forcing NTHC to sell her the house as they had promised. The case first lands in the High Court. The judge listens to both sides. YAA presents her letter, highlighting the words first offer, the price, and the deadline. NTHC argues that their letter was not a firm offer but merely an invitation to treat. What's an invitation to treat? It's a legal concept that means you're not making an offer, you're just inviting other people to make offers to you. Think of an item in a shop window with a price tag. That's not an offer from the shop. It's an invitation for you, the customer, to come in and offer to buy it. The High Court judge sided with the company. He declared that the letter from NTHC was not an offer. He pointed to the board's language, saying they proposed to sell, which he interpreted as a preliminary step, not a final promise. Therefore, the judge ruled YAA's acceptance was actually the first real offer in this exchange, which NTHC was free to reject. The court concluded that no contract was ever formed. YAA ANTWI's case was dismissed. It was a crushing blow, but YAA was not ready to give up. She believed the judge had fundamentally misinterpreted the letter and the law. She decided to appeal. The case then went to the Court of Appeal. Here, the story takes a dramatic turn. The appeal judges, led by the respected Justice Marfal Sow, took a completely different view. They re-examined the NTHC letter, Exhibit A, with fresh eyes. Justice Marfal Sow declared that, with all due respect, the High Court had made a mistake. He broke it down. The letter identified a specific house. It named a fixed price. It laid out a clear payment period. These, he argued, were the essential ingredients of a legally binding offer. All that was needed to turn this offer into a contract was a simple acceptance. And YAA ANTWI's letter from January 31st was exactly that, a clear, unconditional acceptance. Therefore, the Court of Appeal concluded a valid contract was formed the moment NTHC received her letter. The company's failure to provide bank details was a breach of that contract, not an excuse to cancel it. The Court of Appeal overturned the High Court's decision. They granted YAA ANTWI the specific performance she had asked for, ordering NTHC to sell her the house. It was a huge victory for YAA, but NTHC was a powerful entity, and they were not about to be defeated. They decided to take the fight to the final battleground, the Supreme Court of Ghana. Now, the case reaches the highest court in the land. The stakes are immense. The Supreme Court panel, featuring some of Ghana's most brilliant legal minds like Justice Datebar, Justice Owusu, and Justice Adenyura, prepares to deliver the final word. The lawyer for NTHC stands before them, arguing forcefully. He claims the letter was just the start of negotiations. He even brings up a famous English case, *Gibson v. Manchester City Council, where similar language about a council being prepared to sell a house was ruled to be an invitation to treat, not an offer. He insists NTHC's letter was no different, but the Supreme Court justices are not easily swayed. They begin a meticulous analysis of the letter's text. Justice Deba, speaking for the court, emphasizes the need to go back to the basics, offer acceptance, and the intention to create a legal relationship. Justice Oyusu points out the undeniable facts. The letter identifies a specific property and a specific price. Justice Adenira adds that this constitutes a definite and final proposal that could be converted into a contract simply by acceptance. But what about the word proposed that the High Court focused on? Justice Deba dismisses this. He explains that the first sentence, where proposed appears, is merely introductory. The real substance of the letter comes next, and it uses the much stronger term first offer. The letter, he concludes, has all the key features of an offer. Then they address the Gibson case. Justice Deba distinguishes it brilliantly. In Gibson he explains essential terms like the price were still subject to negotiation. The counsel's letter was deliberately vague, but here, in YAA ANTWI's case, all the essential terms were laid out clearly. The only thing missing was the bank account number, which is a minor detail for executing the contract, not a fundamental term of the agreement itself. The core of the deal was already set in stone. Finally, the moment of judgment arrives. The Supreme Court delivers its unanimous verdict. First, they declare that NTHC's letter was indeed a legal offer. Second, YAA ANTWI's response was a valid acceptance. Third, as a result, a binding contract was formed between them on January 31, 2005. Fourth, the situation clearly showed an intention from both sides to create a legal relationship. And fifth, because land is considered unique, an order of specific performance is the appropriate remedy. NTHC must sell the house to YAA ANTWI. The appeal is dismissed. YAA ANTWI, after a long and arduous legal journey, had won. Justice was served. This case is now a cornerstone of contract law studies in Ghana and beyond. It teaches a vital lesson. The words we use in business matter immensely. A seemingly simple letter can create a binding contract, and once that line is crossed, you can't just change your mind. It's a powerful reminder that the law is designed to uphold promises, whether they are made by an individual or a large corporation. Thanks for watching. This is D'Antonio's Law Series, sponsored by Stan Inc., your leadership, legal and management expert. Like, comment, share and subscribe so you don't miss our next video. See you next time.